Remember that the moment those flashing lights appear in your rearview mirror, your body undergoes a physiological shift that you cannot entirely control. As we move into the heart of May, the roads are increasingly filled with people celebrating the peak of spring, heading to graduations, or simply enjoying the first truly warm weekends of the year. This increase in traffic naturally leads to an increase in law enforcement presence, and for many drivers, the sudden appearance of a patrol car can trigger an immediate sense of dread, even if they haven't done anything wrong. When you see those lights, your brain triggers a release of adrenaline and cortisol, causing your heart rate to spike and your breathing to become shallow. This fight or flight response is designed for survival, but in a legal encounter, it can cloud your judgment and lead to mistakes that are difficult to undo. Officers are trained to look for these physiological markers: trembling hands, avoiding eye contact, or rapid-fire speech. And while these are common reactions to stress, an officer may document them as signs of unusual nervousness to justify extending the stop or requesting a search. Your primary goal during these first few seconds is to regain control of your internal state. Signal early, pull over to a safe, well-lit area, and turn off your engine. Roll down your window and place your hands clearly on the steering wheel. As you sit there waiting for the officer to approach, use that time to breathe deeply and consciously. The air might be getting warmer outside as the season turns, but inside your vehicle, you need to maintain a cool, collected demeanor. One of the most subtle ways an officer begins to build a case is by simply observing how you react to the pressure of the unknown. They may intentionally take several minutes to approach your window, allowing your anxiety to build in the silence. During this time, many drivers begin rehearsing excuses or searching for documents in a frantic manner, which can look suspicious from the officer's perspective. By staying still and remaining calm, you are signaling that you are in control of yourself and the situation. This isn't about being cold or confrontational. It's about preserving your ability to think clearly. When your nervous system is overwhelmed, you are far more likely to agree to things you shouldn't or to offer information that wasn't requested. You might feel the urge to speak first to break the tension, but that is a mistake. The stop truly begins with the officer's first question, and your ability to answer that question without the filter of panic is your first line of defense. Think of this initial phase as a mental reset. You are moving from the role of a distracted driver to that of a focused, informed citizen who understands the gravity of the interaction. By recognizing that the environment of a traffic stop is designed to be intimidating, you can depersonalize the experience and treat it as a formal procedure. This mental shift allows you to listen more carefully to what is being asked and to respond with the precision required to protect your rights. The goal is to exit the encounter with as little friction as possible, and that starts with a calm heart and a clear head. As the spring sun sets later and the days grow longer, the likelihood of these encounters increases, but your strategy remains the same regardless of the time of day. You are the one who decides how much of your internal state you reveal, and by mastering your own reaction to the initial shock of the stop, you deny the officer the ability to use your own natural anxiety against you. Recognizing external stressors, like the noise of rushing highway traffic or the intensity of the overhead lights, as environmental factors rather than personal threats, helps you maintain your composure. When you understand that the officer is also operating within a framework of training and safety protocols, it becomes easier to see the interaction as a professional encounter. You are a participant in a legal process, and every action you take contributes to the narrative of the stop. If you appear frantic, you provide a reason for more inquisitiveness. If you appear calm, you set a tone of mutual respect. Once the officer is at your window, the interaction moves from a psychological preparation to a physical exchange of information. This is the moment where your preparation pays off. You should have your hands clearly visible on the steering wheel, and if it's dark outside, Having your interior light on is one of the most effective ways to lower the officer's tension. When the officer asks for your license, registration, and proof of insurance, your response should be measured and predictable. Avoid reaching for your wallet or glove box the second you see the lights. Wait until the officer is at the window and has made the request. Before moving your hands from the wheel, inform the officer of what you are about to do. A simple statement like, "My license is in my back pocket and my registration is in the glove box. I'm going to reach for them now," removes any ambiguity from your movements. This transparency is a powerful tool for de-escalation. From the officer's perspective, a traffic stop is a high-risk encounter with many unknowns. By narrating your actions, you are eliminating those unknowns and demonstrating that you are not a threat. This creates a safer environment for everyone involved and often sets a tone of professional, mutual respect that can influence the outcome of the stop. Even if you feel the stop is unjustified, the window is not the place to litigate the matter. Your goal here is to be the most boring, compliant, and forgettable person the officer meets all shift. The second subtle trick often occurs during this document exchange. An officer may engage you in what seems like casual small talk while you are looking for your paperwork. They might ask, "Have you had anything to drink tonight?" Or, "Where are you coming from in such a hurry?" It is easy to feel that you must answer these questions to appear cooperative, but these are investigative inquiries designed to elicit a confession or provide a reason for further detention. You can remain perfectly polite while declining to engage in this line of questioning. A respectful way to handle this is to focus entirely on the administrative task at hand. You can say, "Officer, here is my license and insurance," effectively redirecting the conversation back to the legal requirements of the stop. If they persist with questions about your whereabouts or activities, you have the right to remain silent. But in the context of a traffic stop, a polite, "I'd prefer not to discuss my day, but I'm happy to provide whatever documents you need," is often the most effective way to de-escalate without surrendering your privacy. You are satisfying the legal requirement to identify yourself and prove the vehicle is legal to operate, which is the primary purpose of the stop. By keeping the conversation strictly professional and focused on the paperwork, you are narrowing the scope of the interaction and preventing it from expanding into a fishing expedition. Communication during this phase should be clear and concise. Avoid rambling, as nervous chatter is often interpreted by law enforcement as a sign of guilt or deception. Use formal titles such as officer or deputy, as this reinforces the professional nature of the encounter and shows that you acknowledge their authority without being submissive. If the officer asks you to step out of the vehicle, you should generally comply. While the laws regarding why an officer can ask you to exit vary, the Supreme Court has largely upheld this as a safety measure for the officer. If this happens, do not argue. Step out slowly, keep your hands visible, and continue to maintain your calm demeanor. It is important to understand that complying with an order to exit the vehicle is not the same as consenting to a search or waiving your right to remain silent. It is simply a response to a lawful command regarding the mechanics of the stop. Once you are outside the vehicle, the physical dynamics change, but your strategy remains the same. Be polite, be predictable, and keep the focus on the specific traffic violation that initiated the stop. By maintaining this level of disciplined communication, you are protecting yourself from the subtle psychological pressure that often leads drivers to provide more information than is legally required, while also ensuring that the encounter remains as safe and standard as possible for both parties. The transition from a standard traffic stop to a focused criminal investigation is often so seamless that many drivers don't even realize it has happened until it is too late. This shift usually begins with questions that seem unrelated to why you were pulled over in the first place. An officer might ask, "Do you have anything in the car I should know about?" Or, "Is there any reason a K-9 unit would alert to your vehicle?" These are not just casual inquiries. They are strategic tools used to gauge your reaction and elicit a waiver of your constitutional rights. One of the most effective ways an officer can bypass the need for a warrant or probable cause is by obtaining your voluntary consent. They might frame the request in a way that makes it seem like a mere formality or a way for you to prove your innocence, saying something like, "If you've got nothing to hide, you won't mind if I take a quick look, right?" It is crucial to understand that you have a fundamental right under the Fourth Amendment to refuse this request. Saying no does not give the officer legal grounds to search. In fact, it is a protected act. You can be entirely polite and respectful while stating, "Officer, I do not consent to any searches of my person or my property." By doing this, you are not being difficult. You are exercising a right that exists to protect everyone. If you choose to give consent, you are effectively giving the officer a blank check to search every corner of your vehicle, and anything found, regardless of how it got there, can be used as evidence against you. Once consent is given, it is very difficult for a lawyer to challenge the search later because you legally agreed to it. In addition to seeking consent, officers are trained to use the plain view doctrine to their advantage. While the interior of your car is generally protected, anything an officer can see from a lawful vantage point outside the vehicle is not considered a search in the legal sense. This is why an officer will often walk around the vehicle and shine a high-intensity flashlight into the back seat, the floorboards, and the center console. If they spot something that is immediately identifiable as contraband or evidence of a crime, they may then have the probable cause necessary to enter the vehicle and conduct a full search without your permission. This high-level legal concept of probable cause is the threshold required for many law enforcement actions, but its definition can be surprisingly fluid and varies significantly across different state lines. For instance, in some jurisdictions, the mere smell of an illegal substance might be enough to trigger a search, while in others the law has evolved to require more substantial evidence. Because you cannot be expected to know the minute details of every local ordinance or state Supreme Court ruling while sitting on the shoulder of a highway, the safest and most consistent strategy is to never volunteer information or consent. By remaining silent on these matters and refusing searches, you create a clear legal record. If an officer chooses to proceed with a search anyway, they must be able to justify their actions in court later based on specific facts, rather than relying on the fact that you simply let them in. Another tactic involves the subtle use of time and psychological pressure, often referred to as prolonged detention. The law generally dictates that a traffic stop should last only as long as it takes to address the initial reason for the stop, such as issuing a speeding ticket or checking for a broken taillight. However, an officer may attempt to extend this window by engaging you in an investigative side mission. They might tell you to wait while they call for a drug-sniffing dog or wait for a second officer to arrive. If the original purpose of the stop has been completed, meaning the officer has checked your documents and decided whether to give you a ticket, and they are still holding you, the stop may have become an unlawful detention. In these moments, you can respectfully ask, "Officer, am I free to go?" Or, "Are you detaining me or am I free to leave?" If the officer says you are free to go, do so immediately and calmly. If they tell you that you are not free to go, you are now in a formal detention. At this point, the most protective action you can take is to stop answering questions entirely. You can say, "I am going to remain silent and I would like to speak with an attorney." This shift in the interaction is often the most stressful part of a stop, but it is where your commitment to your rights matters most. By recognizing these maneuvers, the request for consent, the search for plain view evidence, and the attempt to stretch the duration of the stop, you can maintain your composure and ensure that the encounter stays within the bounds of the law. You are not required to assist the officer in building a case against you, and staying calm while asserting your rights is the best way to handle these escalation edges. When a traffic stop moves beyond a simple citation and into the realm of a serious investigation, you will likely encounter the most intense psychological pressure of the interaction. This is the edge of escalation, where the officer's tone may shift from professional to confrontational, or conversely, to an oddly sympathetic friend persona. One of the most common tricks used during this phase is the implication that your silence is an admission of guilt, or that only a guilty person would need a lawyer. The officer might say something like, "Look, if you just tell me what's going on, I can help you. But if we have to do this the hard way, it's going to be much worse for you." This is a powerful psychological tactic designed to make you feel that asserting your constitutional rights is a hostile act or a sign that you are hiding something. In reality, the decision to remain silent is a neutral legal protection that is fundamental to the American justice system. It is not an act of obstruction. It is a choice to let the legal process unfold through the proper channels rather than on the side of a highway under duress. When you feel this pressure building, it is essential to remember that you are not in a position to negotiate your way out of a potential arrest. Anything you say in an attempt to clear things up can and often will be used against you later, even if you are entirely innocent. The safest and most factual course of action is to clearly and respectfully state that you are invoking your right to remain silent and that you would like to speak with an attorney. Once you have made this statement, you should actually stop talking. This can be incredibly difficult, as humans naturally want to fill awkward silences or defend themselves against accusations. But every word spoken after you have invoked your rights can complicate your legal standing and provide the officer with new avenues for investigation. Another subtle trick involves the false statement of fact, where an officer might tell you they found something or that a witness saw something, even if it isn't true, in an attempt to provoke a reaction or a contradictory statement. They are legally allowed to use certain types of deception during an investigation in many circumstances. This is why sticking to a strict, no comment stance is so vital. If you try to correct their facts or point out their lies, you are engaging in the very dialogue they want, and you may accidentally reveal information you didn't intend to. Staying safe during this high-stakes moment means keeping your hands visible and avoiding any sudden movements, as the officer's stress level is likely as high as yours. If you are placed under arrest, the time for talking has passed completely. Do not resist, do not argue, and do not attempt to explain yourself in the back of the patrol car. The patrol car is almost certainly equipped with recording devices that capture everything you say, and any venting or emotional outbursts can be used as evidence of your state of mind or as a spontaneous confession. Your silence is a shield, not a sword. It protects the integrity of your future legal defense by ensuring that the only evidence against you is that which was lawfully gathered, rather than words spoken in a moment of extreme stress. Understanding these escalation edges allows you to remain grounded when the officer's tactics become more aggressive. You are participating in a process where the officer has one role, to gather evidence, and you have another, to protect your legal interests. These roles are naturally at odds in an investigative setting, and recognizing this allows you to remove the emotion from the encounter. You are not being difficult or anti-police by remaining silent. You are being a disciplined citizen who respects the complexity of the law. By maintaining a factual and calm demeanor, you ensure that you do not provide the officer with any behavioral evidence of aggression or non-compliance that could be used to justify a more forceful intervention. This is the stage where the stakes are highest, and your adherence to the principle of silence is your most effective tool for staying safe and preserving your future. Remember that the officer's goal is to close an investigation, and your goal is to ensure that your rights are not bypassed in the process. Silence is not a lack of cooperation. It is a request for the process to be handled by professionals in a controlled environment. Even if you believe the officer is being unfair or acting outside their authority, the side of the road is not the place to settle that dispute. You win by staying calm, staying safe, and speaking only through a qualified attorney who can represent your interests with the benefit of time and legal expertise. The interaction does not truly end when the officer walks back to their patrol car and releases you. Instead, it transitions into a critical phase of documentation that could prove vital if the stop leads to any form of legal proceeding. As you pull away and find a safe, quiet place to park, your first priority should be to capture the details of the encounter while they are still vivid. Adrenaline has a way of sharpening some memories while blurring others, so writing down a chronological account is the most effective way to preserve the facts. Note the exact time and location of the stop, the name and badge number of the officer, and the patrol car's identification number if you were able to see it. Describe the initial reason the officer gave for pulling you over, and most importantly, the sequence of the questions they asked. Did they ask where you were coming from before asking for your license? Did they ask to search the vehicle? And if so, how was that request phrased? Your notes should include whether you gave consent, whether you invoked your right to remain silent, and at what point you felt you were no longer free to leave. If you have a dash cam or if you recorded the interaction on your phone, ensure that the footage is backed up and saved in a secure location immediately. This record serves as an objective witness to the events, providing a level of detail that even the best memory cannot match. Avoid the temptation to share the details of the stop or your frustrations on social media. Instead, keep your documentation private and treat it as a sensitive legal record. If you received a citation or were arrested, this information will be the foundation upon which a qualified attorney builds your defense. They will look for procedural errors, inconsistencies in the officer's account, or potential violations of your constitutional rights. By being diligent in your documentation, you are providing your legal counsel with the tools they need to represent you effectively. It is important to approach this post-stop phase with the same level-headedness you maintained during the interaction itself. This documentation mindset is about being an active participant in your own legal protection. You are creating a snapshot of the event that can be compared against the officer's official report later. Sometimes small details like the weather conditions, the visibility of road signs, or the specific wording used by the officer to gain a psychological advantage can make a significant difference in a courtroom. Think of this process as a debriefing session with yourself. Ask yourself if there were any witnesses or if there were nearby businesses with surveillance cameras that might have captured the stop. If the stop resulted in a search, note exactly what was searched and how long it took. The more specific you are, the better. This disciplined approach ensures that you are not relying on emotion or vague recollections when discussing the matter with a professional. Finally, it is essential to understand the limitations of the information provided throughout this series. The concepts discussed, such as the dynamics of consent, the plain view doctrine, and the importance of remaining silent, are high-level educational frameworks intended to help you understand general legal principles and common police tactics in the United States. This voiceover and the accompanying materials do not constitute personalized legal advice, and viewing or listening to this content does not create a lawyer-client relationship between us. Laws regarding traffic stops, searches, and driver obligations vary significantly from state to state and can change based on new court rulings or legislative updates. Every situation is unique, and the specific facts of your encounter will dictate the best legal strategy. Because of this complexity, you should always verify the laws in your specific jurisdiction and consult with a qualified, licensed attorney in your area if you have legal questions or are facing charges. A local lawyer who understands the nuances of your state's statutes and the tendencies of your local courts is an indispensable resource. By combining a solid understanding of your general rights with the specific expertise of a local professional, you put yourself in the best possible position to navigate the legal system successfully. Your goal is to be an informed, respectful, and prepared citizen, and that preparation continues long after the flashing lights have disappeared from your mirror.